So you've seen our series on mediation, and here's reason number 42 why mediation might be a good option. If you're in any kind of dispute or conflict with another person or a company, whether it's a court case, full-blown litigation, just an argument, dispute, maybe a contract conflict, mediation has many advantages. And this particular advantage we're talking about has to do with confidentiality. Confidentiality. So if you have a conflict that goes to court, even before you enter the courtroom, you're going to have to exchange information with the other party through things like discovery, through depositions, through product description, production of evidence, even witness interviews. All of those pieces of evidence collected by you or the other side are subject to publication, meaning that they're part of the public record. So if you turn over things about your product information of your company or your customer information, or you give a deposition, that deposition is part of the public record for the court. Now remember, we're not attorneys, we're not giving you legal advice, but most things that go into the court record are public record. The court record by definition is public. However, there's an exception. If you do mediation, anything discussed in the confines of that mediation event is confidential. So you can reveal things, you can talk about things, you can use information as leverage to help your cause. You can reveal maybe what you're willing to accept. You can also discuss things about your case with your mediator or even with the other party that can't be used in publication. So if you have, let's say, sensitive things about, your family matters or your business matters, a mediator is not allowed to reveal those, and the other side is not either. Now, here's the thing. There's a couple exceptions to that. If you discuss anything that's a threat to somebody's physical well-being, you threaten to hurt somebody, or you're discussing an ongoing or future crime, those are exceptions. But obviously, that's not a normal thing. The information used for settlement, negotiations, that's all subject to confidentiality. And many clients like to use mediation as an alternative to the court process because they don't want their dirty laundry aired out in public, right? It might not be right away, but maybe 2, 3, or 5 years from now, somebody can pull up this court case and say, hey, wait a minute, 5 years ago, this person revealed this about themselves, or they disclosed this document, or they put this on record that this is how they feel about something. Where mediation, none of that happens. None of it goes out into the open ecosystem. So if you're at all concerned about your privacy today or tomorrow, mediation may be a way to evade that disclosure in a courtroom setting. Now, there's other advantages. First of all, you don't have to abide by whatever the mediation comes up with. It's totally voluntary. If you don't like the outcome or what's suggested, you can walk away. But the main thing is it's all confidential. Even if you offer something and it's not accepted, that offer can't even be used against you later. It can't be said, well, you offered this before, so I want to take it now. You don't have to abide by your offer after the mediation is over with. And that offer can't be used as leverage against you in court to make you accept a settlement or negotiation at a later date. Maybe something changed. Maybe you don't want to accept that settlement anymore. The most important thing is you'd be surprised what's going to come out in court, things you have to testify to, because in a deposition, you can't object to questions, right? If you're in court, you see it on TV all the time. The attorney asks a question and the attorney says, I object. I don't have to answer that. Privacy, plead the fifth, whatever it is. But here's the thing. In a deposition, you can't object to a question. You have to answer the question in the deposition. Now, it may not be able to be used in court, but that transcript of that deposition still has that answer. And you've seen many times recordings, videos of depositions of famous people, right? Former presidents and high-profile business people make it into YouTube. So think about that before you go into a deposition or start revealing evidence. Do you want this out in public, this information about you or your business or your family or whatever it is? And so you might be able to use a mediation, even if it's not court required, to enable you to get a result in your conflict without having to reveal very sensitive things about your history, your person, or your company.